On a bitterly cold day in Middlesbrough, December 9th, 1999, a long-running civil battle came to a head. The courtroom was tense as Judge Michael Taylor delivered a judgment that would leave the claimants stunned and determined to fight on. This wasn't just any civil claim. It had all the hallmarks of a legal thriller: a botched criminal investigation, shadowy underworld figures, allegations of malicious intent by public officials, and a deeply troubling miscarriage of justice. Or so the claimants believed. The roots of the case stretch back to January the 31st, 1991. An armed man named Mr. Duffy, rumoured to be a major player in the drug trade, allegedly tried to coerce a young woman into becoming a dealer. Soon after, she found herself at the centre of a police investigation. She claimed to have suffered a miscarriage while in custody, only for medical staff to determine she hadn't even been pregnant. The police, meanwhile, failed to link her to the violent offences under investigation, but still found £900 in cash and drug paraphernalia in her possession. Then came the involvement of John Leroy Thomas, a man with a fearsome local reputation as a fence for stolen jewellery, and two other individuals who flatly denied involvement. They even volunteered for an identity parade, but in a bizarre twist, the prosecution's star witness refused to testify in court. The Crown dropped all charges. The claimants were acquitted. Yet, 3 years later, they returned, not to the dock, but to the civil courts. Their argument that what they had suffered was not simply misfortune, but misfeasance in public office. They accused the police of abuse of power. They alleged that a suspect had been plied with brandy while under questioning. They questioned the entire handling of key witnesses. They said the system had been twisted against them, but in 1999, Judge Taylor dismissed their case outright. Now, the matter was before the appellate court, but not all of it. The appeal had been granted on just one razor-sharp point: misfeasance in public office. The stakes couldn't be higher. Did the police, entrusted with power, cross the line into corruption? Was the justice system manipulated to protect questionable investigative practices? Or was this simply a case of disappointed claimants grasping at legal straws? The answer lies in the appeal, and what unfolds is a striking examination of police conduct, legal limits, and the elusive line between incompetence and intent. This is a case where the devil is in the detail, and where the outcome, until the final words are spoken, remains far from certain. This is a claimant's appeal from a decision of Judge Michael Taylor, who, on the 9th of December 1999 at Middlesbrough, dismissed the claimant's action against the defendant. Permission to appeal was granted by the single Lord Justice in relation to one head of claim only, namely the allegation of misfeasance. The background to this civil action is a criminal investigation which resulted in the acquittal of the two claimants. The offences which gave rise to the investigation were committed on the 31st of January 1991. At 2 a.m, there was an armed robbery at the home of Lisa Stockwell at Eston, Teesside. At 3 a.m, her boyfriend Lee Paul Duffy was shot in the leg at a blues party nearby. He was well known locally to be involved in drugs, dishonesty and violence, but contract shooting was not then a feature of Teesside crime, so the incident caused the police considerable concern. Statements were obtained from the eyewitnesses at Eston and from Mr. Duffy. The descriptions of the offenders were not particularly consistent, but one woman, Ria Maria Nazir, was thought to be able to help. Mr. Duffy, armed with a gun, had recently visited her and, together with his henchmen, tried to recruit her as a drugs dealer. On the 2nd of February 1991, she was brought by two police officers to the police station. After a time, she was seen alone by Inspector Mallon, who has subsequently become a well-known name. There were no tape recording facilities at the police station at that time. No contemporaneous note was made. It was the Crown case that, whilst alone with the inspector, Ms. Nazir admitted involvement in the attempted murder, and immediately afterwards, the inspector instructed the two police officers who had brought her to the police station to arrest her on that charge. That was done. She was then interviewed by the two officers. The judge found that interview to have been properly conducted, and in it, the admissions were repeated. For that interview, she did not have the services of a solicitor, but after she had seen a solicitor, she attempted, as the judge found, to backtrack. She also tried to create a diversion. She said that she had miscarried at the police station and was removed to hospital, where it became clear that she had not even been pregnant. There was a suggestion that in hospital she made some attempt at suicide, but there was no real support for that suggestion. While she was in hospital, her home was searched. The police found nothing to link her with the offences of the 31st of January 1991, but they did find the paraphernalia of a drugs dealer and £900 in cash. On the 5th of February 1991, while still in hospital, Miss Nazir asked to speak to a senior police officer. Superintendent Miller and Inspector Leonard went to see her. They were in charge of the investigation into the attempted murder, as it was then believed to be, and the robbery and the burglary. She wanted to do a deal. If not prosecuted, she would give information about the crimes committed on the 31st of January 1991. Superintendent Miller discussed the proposal with Keith Simpson, a senior local Crown Prosecution Service Crown prosecutor, and with Keith Lee, Miss Nazir's solicitor. The police officer wanted to get at the men who had used weapons, and Mr. Simpson agreed. The solicitor was naturally anxious that his client be free. On the 6th of February 1991, after she was returned from hospital to police custody, the deal was done, and she made a long statement in the presence of 2 women, police officers, and her solicitor or his representative, with occasional visits from Superintendent Miller. At 4 p.m, her extended custody time limit expired and she was bailed, but she remained to complete the statement. At 6 p.m, her solicitor, Mr. Lee, came in and found her drinking brandy from a small brandy bottle. He did not intervene or express concern. Superintendent Miller never saw her drinking, but one of the women police officers recalled that she did so. The brandy, as the judge found, was hers. It was with the property restored to her when she was granted bail. She was a known alcoholic, but on the evidence the judge found that she had her senses about her and was able to give information. At that stage she did not identify the men involved on the 31st of January beyond indicating a link with Birmingham, saying that she had turned to Birmingham for help to sort out Mr. Duffy. No doubt, to try to prompt some identification, she was shown photographs. The judge was caused, as he put it, a degree of disquiet by the fact that no proper record was made of the use of photographs. The police had, or later acquired, some other evidence to link Teesside and Birmingham. There was a white BMW motor car, which had been seen locally and in company with Miss Nazir's Honda Civic. There were also telephone records that linked Miss Nazir and her brother-in-law, John Leroy Thomas, in Birmingham, and also linked these 2 claimants. Miss Nazir was taken to Birmingham, and there she gave police officers the names of John Leroy Thomas and the 2 claimants. John Leroy Thomas was a notorious local fence specializing in jewelry. Jewelry had been taken at the time of the robbery. His appearance was such that he could have been the 3rd man described by witnesses, and he owned a white BMW. The 2 claimants had criminal records and had been involved with robberies, and in the case of the 2nd claimant, with firearms. All 3 were arrested and taken to Teesside. John Leroy Thomas was arrested on the 27th of February 1991, and at that time had on him some 940. They all 3 denied involvement, and the 2 claimants offered at that stage to take part in an identification parade. Off the record, John Leroy Thomas gave some information, and Miss Nazir tried to broker a deal for him. Her solicitor, who also became his, Mr. Lee, saw Superintendent Miller, who, as the judge found, was less anxious to do a deal than he had been in the case of Miss Nazir. He was prepared to consider what charge should be preferred, and, if he received cooperation, to say so to the court. But, in the event, John Leroy Thomas was charged with conspiracy to murder. As Mr. Lally, who has appeared before us for the appellants, points out, he was never charged with robbery or burglary. On the 25th of April 1991, the senior police officers involved in the investigation and the representative of the Crown Prosecution Service met counsel in conference, and amongst other things, the question of an identification parade was discussed. Inspector Beach, who had been appointed identification officer, asked the two claimants if they would take part, and they refused to do so. Therefore, the police photographed the two claimants and separately photographed a number of volunteers, everyone being photographed at the charge office. Thus, the police were in a position to create a video film which they showed to potential identification witnesses in the presence of the claimant's solicitors. The second claimant's solicitor objected to the procedure, but Inspector Beach decided to go ahead nevertheless. The second claimant was positively identified by Wendy Stockwell and Nicola Richardson in relation to the burglary or robbery. Miss Nazir did not at first identify him. She indicated a desire to say something different and was allowed to see the film again in the presence of the first claimant's solicitor. She then identified the second claimant on both matters. Committal proceedings followed, at which Miss Nazir gave evidence confirming the involvement of John Leroy Thomas and both claimants and others. The case was committed for trial. In October 1992, shortly before the hearing in the Crown Court was due, the indictment was amended on the advice of leading counsel. The allegation of conspiracy to murder was abandoned. In its place, there was substituted an allegation of conspiracy to cause grievous bodily harm, which reflected the evidence which at that stage Miss Nazir was expected to give. However, when the case reached the Crown Court in that same month, Miss Nazir refused to give evidence and the prosecution offered no evidence in relation to either matter, so the claimants were acquitted. These civil proceedings were commenced 3 years later in 1995 with allegations of malicious prosecution and misfeasance in public office. Shortly before the trial began in late 1999, an attempt was made to add allegations of negligence and breach of statutory duty, but the trial judge refused to allow the late amendments. He did, however, allow the claimants to expand the factual basis of their case. In his judgment, he rejected the allegations of malicious prosecution, and that is no longer a live issue before us. He also rejected the allegations of misfeasance. As Mr. Robert Smith, QC, for the respondent, points out in his skeleton argument, it is instructive to see how this case was presented in the pleadings and in the court below. It was presented as a case of dishonesty, where the police had acted with corrupt and improper motives, and had dishonestly abused their power with the intention of injuring the claimants by getting them convicted at any cost. That case was, in effect, destroyed by the factual findings of the trial judge, which I have attempted to summarize, but nevertheless it is contended that there is something left of the allegation of misfeasance which is worthy of further consideration by this court. I turn therefore to the grounds of appeal. In ground 1, it is asserted that the trial judge erred in law in respect of misfeasance. The judge gave judgment on the 9th of December 1999, 5 months before the House of Lords gave judgment in Three Rivers District Council and others v. Governor and Company of the Bank of England, 2000, 2 WLR 1220, which is now the leading authority in relation to this branch of the law. Counsel for the appellants and the trial judge did have the benefit of the judgment of Mr. Justice Clark in Three Rivers. That judgment, which was approved by the House of Lords, was reflected in written submissions placed before the judge by leading counsel for the appellants. The judge adopted counsel's formulation, saying at page 19 of the transcript, "As far as misfeasance is concerned, again no great dispute taken by the defendant as to how misfeasance is committed. Misfeasance, or malicious abuse, is committed by a public officer in one of two of the following ways. Firstly, where a public officer does something for a malicious motive which causes damage for the plaintiff, and secondly, where damage is caused by a police officer knowingly doing something which he has no power to do." That means that Mr. Lally in this court can only submit that the judge erred if he was misled by counsel in the court below, which is not contended, or if, as a result of the decision of the House of Lords, it is clear that the law is not as the judge believed it to be. But in my judgment, the decision of the House of Lords, as applied to the facts of this case, shows that the judge was right. The leading speech was that of Lord Stein, who at page 1230 onwards set out the ingredients of the tort. At page 1231b, under the heading, "The third requirement concerns the state of mind of the defendant," he said, "The case law reveals two different forms of liability for misfeasance in public office. First, there is the case of targeted malice by a public officer, i.e., conduct specifically intended to injure a person or persons. This type of case involves bad faith in the sense of the exercise of public power for an improper or ulterior motive. The second form is where a public officer acts knowing that he has no power to do the act complained of, and that the act will probably injure the plaintiff. It involves bad faith inasmuch as the public officer does not have an honest belief that his act is lawful." At 1231g he continued, "There are not two separate torts. On the other hand, the ingredients of the two forms of the tort cannot be exactly the same, because if that were so, there would be no sense in the twofold classification. Undoubtedly, there are unifying features, namely the special nature of the tort, as directed against the conduct of public officers only, and the element of an abuse of public power in bad faith. But there are differences between the alternative forms of the tort, and it is conducive to clarity to recognize this." Pausing there, it is worth noting that in the present case it was the first form of the tort, targeted malice, which was alleged. But either way, bad faith was, as the House of Lords makes clear, an essential ingredient. Lord Hope agreed with Lord Stein and Lord Hutton in relation to this aspect of the case, as did Lord Millet. So I turned to Lord Hutton, who, at page 1266f, said, "My lords, I consider that dishonesty is a necessary ingredient of the tort, and it is clear from the authorities that in this context dishonesty means acting in bad faith. In some cases the term dishonesty is not used, and the term in bad faith, or acting from a corrupt motive or an improper motive, is used, or the term in bad faith is used together with the term dishonesty." He gives some examples and continues, "However, as the term dishonesty in some contexts implies a financial motive, I consider that the term in bad faith is a preferable term to use, and, as I have stated, I consider that it is an essential ingredient in the tort." Mr. Lally invited our attention to parts of the speech of Lord Hobhouse. "I do not myself believe that those passages are at odds with the passages I have cited. If I am wrong as to that, the passages cited still represent the decision of the House, and, as Mr. Lally in the end accepted, they do not demonstrate error on the part of the trial judge." I move therefore to ground 2. In paragraph 17.1 of their amended particulars of claim, the appellants give 10 particulars of alleged misfeasance, and they now complain that the judge failed in his judgment to address 3 of those particulars. There is a misprint in the notice of appeal in relation to the last number. Paragraph 17.1 of the amended particulars reads, "Allowing the charges against John Leroy Thomas for robbery of the Stockwells to be dropped, and reducing down the offence of attempted murder to that of attempted assault, when there was sufficient evidence to suggest that he was involved in the attempted murder, or alternatively the conspiracy to murder, or to cause grievous bodily harm in the robbery." In fact, John Leroy Thomas never was charged with robbery, and as I have already indicated, the charge of conspiracy to murder was reduced to conspiracy to cause grievous bodily harm in respect of all defendants, on leading counsel's advice. Why he was not charged with robbery or burglary is not clear to me at this stage, but even if the charge was withheld in order to encourage him to give information about his co-accused, I do not see how that could possibly amount to misfeasance. The next particular of misfeasance referred to in ground 2 of the grounds of appeal is paragraph 17.1 of the amended particulars, which reads, "Allowing Miss Nasir to administer brandy whilst being detained and questioned in the investigation at the police station. This apparently relates to the incident at about 6 p.m. on the 6th of February 1991, to which I have already referred, but as is clear from the narrative, Miss Nazir was not then in custody. The police officers who saw her drinking could perhaps have discouraged her from doing so, but apparently neither they nor her solicitor did discourage her. The reality is that the police wanted the statement that she was then giving. To my mind, the judge was right not to regard this as any evidence of misfeasance. The final particular of misfeasance referred to in Ground 2 of the Grounds of Appeal is paragraph 17.1 of the amended particulars of claim. It reads, allowing Ms. Nasir to induce John Leroy Thomas to give evidence by administering him with brandy. The incident is not referred to in the judgment. It seems that on 2nd March 1991, when John Leroy Thomas was in police custody, he was visited by his sister-in-law, Miss Nazir, who was allowed to speak to him in private with a police officer outside the room. When her solicitor entered, he found her pouring brandy from a bottle in her possession into John Leroy Thomas's soft drink container. Apparently, she was also trying to persuade him to cooperate with the police. There was, as Mr. Smith points out, no evidence that the police knew what was going on. The judge, clearly, at least by inference, rejected the suggestion that the police were trying by improper means to induce John Leroy Thomas to give evidence against his co-accused. Furthermore, the reality is that he never did so, or even agreed to do so, from which it follows that his access to brandy had no effect at all on the appellants, even assuming he was allowed to continue to have it, and it cannot possibly amount to misfeasance. Ground 3 begins with these words. The learned trial judge was plainly wrong in not establishing that the defendants had acted in misfeasance, given the following. There followed 8 particulars. The first relates to the decision not to prosecute Miss Nazir. Mr. Simpson of the Crown Prosecution Service, in reliance on a file note made some several days later, said when he gave evidence in the present proceedings that when that decision, that is to say, the decision not to prosecute Miss Nazir, was taken, he was only aware of her admissions to Detective Inspector Mallon, those being admissions which it would be very difficult to adduce in evidence. Clearly, he should also have been informed of her admissions to the 2 interviewing officers. The assertion now is that Superintendent Miller deliberately or recklessly withheld that information. This is not an allegation that was ever pleaded, and so it was not fully explored with Mr. Simpson. Furthermore, it was never even put to Superintendent Miller beyond an assertion that he downplayed the effect of the evidence. The point was not developed in argument in the court below. In the circumstances, the judge could not safely have found that Mr. Simpson was not fully informed. In any event, it is clear from the rest of his findings that he could find no bad faith and no dishonesty. The second particular relates to the immunity granted to Miss Nazir. It reads, in granting a local immunity, in not prosecuting Ria Maria Nazir for the attempted murder, causing grievous bodily harm and or drug offences, rather than going to the DPP. There was no evidence that procedurally the question of immunity should have gone to the Director of Public Prosecutions. The judge found, at least if Mr. Simpson was properly informed, that there was no irregularity. Particulars relate to the consumption of brandy at the police station by Miss Nazir and John Leroy Thomas. I have already dealt with those matters. Particular deals with the failure to charge John Leroy Thomas in respect of the robbery. Again, I dealt with that matter earlier in this judgment. Particular deals with the return of money to Miss Nazir and to John Leroy Thomas, and the judge did, not surprisingly, express some concern about this. The fact is that 1. Miss Nazir got her 900 back on 15th February 1999, 9 days after she made her statement on 6th February 1999. 2. John Leroy Thomas got back his 940 on the 26th of March 1999, just under 4 weeks after his arrest. As a result of what seems to have been an administrative error, both were repaid for a second time after the conclusion of proceedings in a Crown Court, but, as Mr. Lally accepts, nothing can now turn on that. Mr. Lally's submission is that the earlier repayments are indicative of misfeasance because of the weight of evidence against Miss Nazar and John Leroy Thomas. But, as it seems to me, once it was decided not to proceed against Nazir, she had a right to her money. She could have been charged with drugs offences, but for obvious reasons the decision was taken not to follow that course. Similarly, as Superintendent Miller made clear when giving evidence, he had in his judgment no good grounds for holding on to the 940. He could not show that it was part of the fee for the attack on Mr. Duffy committed 27 days before John Leroy Thomas was arrested. So, in my judgment, the judge was right to find in the end that the repayments did not amount to evidence of misfeasance. Certainly, there was no real room for the inference that the evidence of Miss Nazir and John Leroy Thomas was being bought with their own money. At particular, there is complaint of the handling of the identification procedure. The trial judge expressed disquiet about two matters. One, the fact that the identification parades were not held soon after the two claimants were arrested, and two, the fact that Inspector Beach, the identification officer, did not see the descriptions given by witnesses of the attackers. As to the first, the failure was unfortunate, but it has nothing to do with the tort alleged, given that the two claimants, as the judge found later, refused to take part in an identification parade at all. As to the second matter, Code D of the Codes to the Police and Criminal Evidence Act only requires that the identification officer should be aware of the first description given. He does not need to be aware of all other descriptions, and I do not share the judge's disquiet. The eighth particular given in support of Ground 3 in the Notice of Appeal relates to the handling of Miss Nazir and John Leroy Thomas generally, and adds nothing to the particulars which precede it. At the end of the day, what, in my judgment, makes this appeal virtually unarguable is that the judge, for what I conceive to be good reasons which he gave, rejected the allegation of bad faith. That, as the House of Lords has made clear, was an essential ingredient of the tort, I would therefore dismiss this appeal. Lord Justice Mummery and Lord Justice Laws also agreed with this outcome. Conclusion: misfeasance or misjudgment. After years of legal wrangling, bitter accusations, and claims of official wrongdoing, the appeal was ultimately dismissed. The court, after reviewing the facts and the conduct of the original trial, saw no compelling evidence to support the allegation of bad faith by the police, despite unsettling elements in the case, delayed identification parades, questionable handling of witnesses like Miss Nazir and John Leroy Thomas, and a broader sense of procedural irregularity. None of it, in the eyes of the appellate court, crossed the legal threshold for misfeasance in public office. Judge Taylor's original decision was upheld, not because the investigation had been flawless, but because the claimants could not prove that the failures were malicious, or that police officers had acted in conscious and deliberate breach of their legal duties. The line between incompetence and misfeasance, it seems, remained intact. But the shadows cast by this case are not easily dismissed. The woman who claimed to have miscarried at the police station, only to be told she had never been pregnant. The mysterious withdrawal of Miss Nazir's evidence at the 11th hour. The notorious reputation of Mr. Thomas, who walked away without facing justice. The £900 in cash and drug equipment that the police found, yet never tied definitively to the crime. The questions linger, even if the courts have rendered their verdict. So we ask you, the audience, do you believe the claimants were simply caught in the crosshairs of a flawed investigation, or were they genuine victims of a system that failed to protect their rights? Should failures in police procedure, even if not rooted in bad faith, carry more serious consequences when they impact someone's liberty and reputation? Does the current standard for proving misfeasance in public office set the bar too high, effectively shielding officials from accountability? And finally, if this case happened today, with public scrutiny of law enforcement at an all-time high, would the outcome have been different? Justice isn't always black and white. Sometimes, as this case reveals, it plays out in the murky grey zone between error and intent, where the real answers are left for the public to decide.